All right, if I could call us to order, please. I'm trying to keep us on time. If everyone could.
You need a gavel, Beverly.
I know.
That's my guess.
So I've introduced the panel. I won't do that again, but I was asked to remind you all, if you're seeking CLE for this, you need to sign in and you'll need to sign out to get credit, as well as fill out an evaluation form. So with that, Professor Zakharov, it's all yours.
Thank you, folks. Can we reassemble? We are on a tight schedule. We have a panel that flows in part directly from the last one and in part, folks. Okay, George Berman is going to be removed physically from the premises. Okay, so we have a panel that is on due process concerns in arbitration, and it is going to touch on a couple of different themes. First and foremost, we have a paper by Roger Alford on the types of challenges which are heard to the enforceability of arbitration awards based upon some sense of procedural failure. We have comments on that from people who are quite experienced in this area, Francis and Kathy, who were already introduced, and so I won't go back to the introductions. And then we're going to pivot a little bit to other due process concerns in the domain of arbitration. One is, and this is going to be based mostly on the lived experience of Francis and Kathy, of how does arbitration handle complex cases, and then how does arbitration handle lower value or consumer cases. And the question here is not meant to be preemptive of the panel later today on consumer and labor arbitration, but to introduce some of the doctrinal issues that may carry over from the last panel on throughout the day. So we're going to begin with around 10 minutes from Roger on an empirical paper that he did, and we'll then go to comments on that and then move on to the other parts of the panel. So Roger.
Thanks very much. Thanks for the chance to be here. I haven't been back to NYU since COVID, so it's great to be with you all today and to see all the smiling faces. So I'm going to talk about the emerging industry of empirical research of international commercial arbitration. We have had empirical analysis of investment arbitration for a couple decades, if not more. But there's been almost no empirical research with respect to international commercial arbitration. And so I want to make a case that we should be focusing more on the actual empirical findings that one can draw from the database in cluearbitration.com. And then I'm going to then look at the United States practice with respect to various types of challenges. So earlier this year in the Journal of International Arbitration, Karina Baltag, Monique Sasson, myself, and then an empirical scholar at Notre Dame, Matt Hall, we did a detailed article about international commercial arbitration empirical findings, and we did it both horizontally and vertically, which is to say we looked at all of the different countries that are in the database and what their practices are with respect to enforcement of international commercial arbitration awards, both in the context of offensive actions and vacatur actions. Offensive actions are when the winning party wants to enforce the award, and then the losing party wants to challenge the award. Obviously, the vacatur actions are in the context, as we all know, where the losing party wants to have the award set aside. We did not, in the article, address the third category of defensive enforcement actions, where there's a litigation somewhere and the winning party wants to stop that litigation from moving forward through recognition of the award. So we're not doing defensive enforcement actions. So I encourage you to look at that longer article This article focuses on specific issues related to grounds for challenge in the offensive enforcement action. We're using the language offensive enforcement action to distinguish from the defensive one that I just mentioned, as well as in the context of vacatur. So just a few preliminary comments with respect to the findings. Let me just give you sort of the denominator will be the global practice, and then the numerator, the numerator is going to be the US practice and with respect to these issues. And so it's hard to know exactly what would be all of the due process grounds one could identify. Obviously, we know some of them are fairly easy. Others are a little bit less difficult to say, is that really a due process ground or is it something else? So I went ahead for the sake of inclusiveness, included broader categories than one might necessarily say, ah, that may not be due process. So here are the findings at the global level with respect to offensive enforcement actions. So of the possible due process grounds for challenge, defendants most frequently, so how often are these issues raised by defendants? Defendants most frequently raise public policy arguments 44% of the time, the inability to present one's case 20% of the time, no notice of arbitration proceedings 13% of the time, and not in accordance with the rules of procedure 13% of the time. So one can see that it's not super common to raise due process arguments. It doesn't happen a tremendous amount of time. And obviously public policy is more than just due process. I mean, there's probably a subset of the public policy arguments that includes due process. So one has to take the public policy arguments as a due process ground with, you know, some qualification. In terms of success, this is again at the global level, not the US level. I'm about to get to the US level in a minute. In terms of success, on all grounds, national courts enforce awards 71% of the time and refuse to enforce awards on the basis of one or more arguments under the New York Convention 29% of the time. So 71% success rate. And only 3 grounds for challenge are successful more than 30% of the time. Set aside 34%, the award was not in accordance with the rules of procedure 31%, that the award is not binding on the parties 30%. And then with respect to due process, at the global level, the successive due process challenges were as follows. The award was not in accordance with the rules of procedure 30% of the time. The improper notice of arbitrator appointment 25% of the time. The award was contrary to public policy 19% of the time. Improper notice of arbitration procedures 17% of the time. And the inability to present one's case 11% of the time. Obviously, the last one is the most fundamental one that we think of as the due process argument. To the extent one wants to limit it to just inability to present one's case, only 11% of the time are parties successful in that context. Okay, with respect to the United States experience, of the different possible due process grounds for challenge, the defendants raised public policy arguments in the United States context. And again, with respect to the United States, we're talking about 103 offensive enforcement actions out of 553 in the data set. And with respect to vacatur, we're talking about 32 US decisions out of a data set of 504. Okay, so in the United States, of the different possible due process grounds, public policy 44%, inability to present one's case 20%. I'm sorry, I gave you the wrong statistics. Of the due process grounds for challenge, defendants in the United States raised public policy 35%, raised rules, a violation of the rule of procedure 28%, inability to present one's case 19%, forum nonconvenience 19%, and other due process grounds are much, much smaller. In terms of success, the success of due process challenges were as follows. Improper notice of the appointment of the arbitrator was only raised once, but it was successful. So, you know, it's a very, very limited number. The award was not in accordance with the rules of procedure of the territory where it was relied upon 38% of the time. The award was contrary to public policy 11% of the time. Improper notice of the arbitration proceedings 10% of the time, and inability to present one's case only 5% of the time. So very, very rarely are due process arguments successful in the United States. And the core one that one thinks of in terms of due process inability to present one's case is only successful 5% of the time in which it was raised. So I think one could say in the context of the New York Convention, where one is attempting to challenge the enforcement of an award, due process arguments are rarely successful. They're rarely successful in the United States. They're rarely successful globally. And the fundamental idea of inability to present one's case globally is successful 11% of the time. In the United States is successful 5% of the time. On the vacatur actions, again, that's out of a data set of 504 total in the data set globally. The vacatur actions are as follows. Of the possible due process grounds for challenge in the context of vacatures at the global level, plaintiffs most frequently raise public policy arguments, 37% of the time, the inability to present one's case, 35% of the time, procedures that are not in accordance with the law, 13% of the time, and other due process arguments are raised less than 5% of the time. In terms of the success at the global level, national courts vacated awards only 23% of the time. And they refuse to vacate an award 77% of the time. So vacatur actions are almost always unsuccessful. 23% of the time, or I shouldn't say almost always, 23%, a quarter of the time, they're just under a quarter of the time they're successful. And in terms of due process arguments and the likelihood of success using due process arguments at the global level, the success of due process vacatur actions were as follows: improper notice of arbitrator appointment, 38% of the time; contrary to public policy, 20% of the time; improper notice of the arbitration proceedings, 19% of the time; the procedures were not in accordance with the law, 17% of the time; and inability to present one's case, 11%. The same percentage on offensive enforcement action. With respect to vacatur in the United States, it's difficult to make firm conclusions about that because the data set only has 32 cases in the data set. So one cannot make firm conclusions with respect to the United States experience, but I will tell you what the information does reveal. Plaintiffs in the United States courts most frequently raise the following due process arguments: public policy, 37% of the time; inability to present one's case, 35% of the time; the award was not valid under the applicable law, 16% of the time; and the other challenges are due process challenges are much less. In terms of success in the United States, federal courts vacate arbitration awards only 9% of the time. And they refuse to vacate awards 91% of the time. So a much less likelihood to be successful with vacatur actions in the United States. And then I talked with my Empirical colleague, Matt Hall. Given that there's only 3 of the 32 cases that were successfully vacated, we simply didn't want to say that there were firm conclusions one can draw about it, other than that due process claims, like in every other claim, are rarely successful. So I do want to qualify what I'm saying here in that one has to take the CLUE arbitration database for what it is, which is, I founded the database just over 20 years ago in 2001. And we have approximately 60 country reporters from around the world that talk about significant developments in their jurisdictions, and they make qualitative judgments about which awards should be included in the database. That means that there could be some awards out there that are not included in the database that are yet nonetheless decisions. And so one could say there's selection bias in what is included in the database because the reporters had to make a determination that it was of sufficient interest to the arbitration community to be included in the database. So Deborah Rosen-Plimpton was the country reporter for the United States for almost the entire period of the data set. King and Spalding more recently picked up the US reporting. So the decision by the partners and associates at those firms in deciding what to include in the database has to be some qualifications about the conclusions, what one would draw. Nonetheless, I think it's useful to just realize that parties raise due process arguments relatively frequently, but they almost never win. They're extremely hard to win on a due process arguments. And that's certainly true for the inability to present one's case. I will stop there.
Well, thank you. I have questions for the panelists, but I want to frame it in terms of what Roger has presented. It's extraordinarily difficult to do empirical work about the litigation or dispute resolution process. And there's two sources of empirical difficulty. One of them is how fulsome is the data set? How accurate is it a depiction of what's out there? And there's, Roger mentioned issues of selection bias in how this particular data set was put together. There's human agency involved in it, so it's not a comprehensive data set. So you have to worry about how reflective is it. But the broader problem that everyone runs into with trying to do empirical work about the dispute resolution process is that the overwhelming bulk of cases are bargained in the shadow of the law. And so what you see is the little tip that gets preserved for some kind of dispute resolution mechanism, whether it's the cases that go to court. You know, I teach first-year law students every year. And at the end of first-year civil procedure, every law student knows that he or she has no idea how a case is filed, but they do know for certainty that every one of them goes to the Supreme Court because that's what they've been exposed to. And so you have what's called an attribution problem. You cannot attribute from the select group that has isolated itself out for some kind of further procedures to that of the bulk of the group. And so the entire data set here is 1,000 cases. I don't know the total number of commercial arbitration, international arbitrations that occurred during this period, but I'll throw out a number, 100,000. And so if we're looking at 1,000 that have been preserved for some kind of judicial challenge from the 100,000, it would be a statistical mistake to say that we can assume that this group is reflective of the other group. So the question I want to pose to the panelists, because they really have the lived experience here, is does this stuff make a difference in your day-to-day life? Do you go through the world of advising clients or going into the arbitration process? Or Kathy, you're now an arbitrator. Do you go into this with any concern that there might be voidability at some point as a result of this kind of due process challenge? So Francis, why don't we start with you?
Do you mind if I hijack and actually talk about what we could actually learn from the data just for a minute?
Yeah, go ahead.
Because I do think it's everything you say about the data set is real, right? So we're talking about a data set that was collected for a 10-year window. And just looking at the US cases, there are only 32 vacatur cases reported in that data set for a decade in the entirety of the United States. So we know that that is not even close to the number of real cases. There are only 103 enforcement actions. And we know that there are even more enforcement actions than there are vacatur actions. So the data set is quite limited. I think it's very likely curated so that it includes interesting discussions by courts of issues that practitioners might care about. And so I think you're going to see a bias actually in the granting of vacatur and also in the refusal to enforce in that data set, because that will require an extensive consideration of issues that are serious and interesting.
You're saying that the potentially what is included is more likely to be instances in which they are in fact successfully challenging.
Successful
So the
challenges
run-of-the-mill
to
boring cases are
enforcement
not even
or
gonna get-
successful motions
Yeah,
to
that makes sense.
or actions to vacate. So what the other thing that I think is interesting is if you look at the overall global numbers in the enforcement context, even in this biased data set, you're seeing enforcement 70% of the time, and refusal to enforce 30% of the time. So you're already in this skewed, I think arguably skewed data set, seeing a strong bias toward enforcement, and with the data being pretty similar in the context of vacatur when you're looking at the overall numbers. The thing that was interesting to me is that the US number is identical to the global number. So it's actually 7129 globally and 7129 in the US. So in this curated data set, you've got the US courts functioning in a way, at least in an overall matter, equivalently to what we would call the international standard if you're looking at global cases. So I think that's actually a pretty interesting data point for US practitioners and for those of us who think about marketing to the world, the idea that the United States is a legitimate and good place to hold international arbitrations. I think there would, my guess is that there would be a perception outside the US that you would see more reluctance to enforce and more decisions to vacate awards in the US than in other countries. And so I think that's actually a pretty significant conclusion from the data set. The other thing that I thought was interesting is if you look at this, the subject or the reasons that awards are, or that courts are refusing to enforce awards, just to start with that, in both the US and globally, the number one or the most successful argument is that the award has already been set aside. Now that seems to me unsurprising. What was surprising to me is that for some reason is coming to US courts more frequently than it is globally. So well, actually, I guess when I read it, I thought it was half the time the refusal to enforce was on this ground, but that's actually not what it is. It's that 50% of the time that's raised as the basis for an application. It's granted in the US. It's only granted 34% of the time internationally. Let's market that. You've got a 70% chance of not being successful outside of the US, that the award has already been overturned by a court. That seems a little bit ludicrous to me. And I've got a question for Professor Alford about the second most successful ground. In the article, it says that in both instances, globally and in the US, that the second most successful ground is that the award was not in accordance with rules of procedure. Now, I have to admit that I didn't know what that meant.
Yes, and it's not, as mentioned in the article, it's not a traditional New York Convention ground that you wouldn't say that where in Article 5 is the refusal to enforce because it wasn't in accordance with the procedures, but rather that there are other reasons that are used outside the traditional New York Convention grounds where the courts are saying this is not consistent with our procedures and therefore we're not going to enforce it. So it's almost like an extra textual argument for why we shouldn't enforce this award. I agree with you that it is surprising that it's that high.
Yeah, it's something that if you're doing a next level of analysis of the cases, it might be interesting to pull the cases that fell into that category, both globally and in the US, to find out what that really meant. In other words, when the people creating this data were categorizing decisions in that bucket,
Right.
What did that really mean? Because it to me doesn't sound very familiar, and it's a
high number.
It's a high number in the US. I'm only familiar with the US law, but it was found to be successful 38% of the time.
Well,
and I wasn't clear on what those cases might be.
Well, if you look at the larger article and the grounds that have been identified for not enforcing, we identified in the data set a number of ones that were beyond the New York Convention. And so that's referenced on page 304, I think, of the and 305 of the larger article. So we say, just very quickly, we say, there are grounds where they're not enforced beyond the New York Convention, and they include not in accordance with the procedures of the territory. The award is not yet final. The enforcement was not timely, so statute of limitations arguments, and various other grounds such as improper service of process, procurance by fraud, forum nonconvenience, and manifest disregard of the law. So basically, we identified cases where the courts the defendants either raised an issue or the courts agreed with the issue and refused to enforce it, but it wasn't clear that they were articulating it as a New York Convention grounds, is essentially what I'm trying to say.
So Kathy, let me shift it over to you. You come at this from, you've been general counsel, you've been litigator. I'm not trying to imply you can't hold the job, but you've moved around. We've known each other for many years. And now you're an arbitrator. What resonates from the data? How does that comport with your experience here?
Well, one initial reaction to this discussion just now, I did spend many years as a general counsel. And one of the things that struck me reading the paper is when we talk about only 30% don't get enforced. If I'm a general counsel thinking about whether I want to invest in this process, the idea that I win and 30% of the time I have to start all over again, it's not a great investment.
I just think it's not even close to that number. I think you're going to find that it is single-digit percentages of instances in which the award is not enforced. I
Right,
think
and I think this
it's
goes back to
typically-
Sam's point,
yeah,
that
it's-
we really need to be looking at all of the arbitrations that are out there.
Yeah.
And
I guess,
we recognize that
yeah.
problem, but the question is, where in the world would you ever get that information?
right,
Right.
which raises.
Westlaw. You would go to
another due
Westlaw.
process.
I don't, that may be true for the United States. That's not true for the
You
rest
can't
of
do
the
it globally, but that is the answer in the US.
Well, the way this article is a subset of a much larger article doing global analysis.
So I guess the thing that struck me overall reading the paper is that it both illustrates the real promise of empirical research in this area, but some of the limitations of it too. And I think, the promise, back when I was an advocate, this is a good decision-making tool. I always wanted to be able to tell my clients, how long a particular court takes or what's the likelihood of succeeding on various arguments. But I think we also see some of the limitations here that send you right back to old traditional legal research where you pore over the judicial opinions. In that if our concerns is systemic one of, what's the nature of the justice that is being rendered in these cases, then I think the only way we can get much of a sense of that is to know how serious are the challenges that are being raised here, and are the courts rendering decisions where they don't enforce that sort of force arbitration back into the same procedural mode as litigation with all the pros and cons of that? Or are they deferring to arbitrators who are running wild? Or are they, Goldilocks getting it exactly right? And we can't tell that without digging really into the judicial opinion and the rendering of the history that happened leading to this database.
So Kathy, I don't know what your experience is as a practitioner, but my experience is that courts are very, very, very rarely interfering with arbitration awards. As a practical matter, we litigate with the expectation that if you're arbitrating, that's it. And I think I see Judge Schindlin in the audience, but I think Congress, when it drafted the FAA, made a policy decision to say if parties are going to choose arbitration, then really they don't get access to the courts in most instances. It takes a very extreme circumstance to have a court intervene. And I think the federal judiciary feels authorized by the FAA to take that approach, and with the view that if you choose arbitration, you are inherently, purposely choosing a dispute resolution mechanism that has a lot less process to it. And if you choose it, you can live with it. You're going to have one shot at it. You've picked your decision maker. They make a decision, and that's what you're living with. And I think it's very rare for federal courts to step in. It really does have to be, I think, an extreme situation for that to happen.
Well, but there's another layer to empirical work. In order to do the kind of work that Roger and his colleagues did, you have to flatten the distinction between cases. So you have to reduce every case to its to just a yes, no variable. Did it come out this way? Did it come out that way? And the problem with that is that all you need is one bombshell case that alters the landscape. And then all of a sudden, everybody has to change their conduct, even though in a data set that would appear as a sort of a one-off. So Kathy, I want to go back to the point you raised at the very end of your comment, and this leads into your experience as an arbitrator. to what extent do you think that there is pressure on arbitrations? And we can go through, the standard fare commercial arbitration, or we can go to arbitration involving more complex litigation style issues, or we can go the other extreme toward the consumer cases. But to what extent do you think that the judicialization, if you will, of review has influenced the arbitration process and has forced arbitration to become less flexible, less contractual oriented, and more a mimicry of either the federal rules of civil procedure or some other judicial code of conduct?
Yes, so that's interesting. I think as an advocate, I had the same reaction that Francis does, that you expected the arbitrations to be enforced. As an arbitrator, I find myself a lot more worried about whether, somebody's going to reverse me. And I think that when I talk to other arbitrators, they're even worse than I am about worrying about that. So we do think about it a lot, and probably more than the data would support. But I think my perception is that over the 30 odd years that I have been involved with arbitration in various roles, is that it has become much more like litigation. But I blame it on the advocates. They are used to presenting their case in a particular way in court, and they bring those same concepts to arbitration, I think. I don't think of it as I would expect that a court is going to vacate my award because I didn't grant enough discovery. I find that the two parties come in together and they want to do, 7 depositions, which the rules don't really contemplate. And when I first started out doing arbitrations, you didn't find people doing.
I mean, can I make a comment about that? The encouraging thing that you said, though, is even though it's rare that you will be successfully challenged, it generates the sufficient disciplinary incentives. The possibility is real enough to you as an arbitrator that you actually are really, really careful about crossing your T's and dotting your I's in terms of the way you treat the parties to their arbitration, right? And so it may not be common, but it's sufficiently common that it generates fear in the minds of some of the arbitrators.
I think that's absolutely right.
But the counter to that is I think it leads to arbitration being less efficient than it might otherwise be. So one of the purported benefits of arbitration is that it's cheaper because it's going to be quicker and more efficient. And I think that the considerations that Kathy is talking about, that arbitrators feel like they have to grant discovery when it's sought, or are afraid to rule as a matter of law on a motion to dismiss without having an evidentiary hearing, leads to potentially a expansion of how expensive and how long that arbitration takes.
Summary judgment is almost non-existent.
It's
right?
some motions to dismiss, maybe to narrow, but usually not to get rid of the case altogether. And summary judgment does not happen. No one even tries, I don't think. Because if you've gotten that far, you might as well just, you recognize you're going to go to hearing. The rest of what it results in, because you're not getting these interim decisions from the arbitrators, you also have less chance of settling. So one of the really marked differences for us, for my firm in our experience with largely commercial arbitrations, is that our court cases settle 99% of the time. Our arbitrations don't settle 99% of the time. And it is a function of the fact that you haven't gotten any kind of interim decision or any kind of pivot point. Arbitrations start and they go all the way to hearing.
Right.
And there's really no, I think panel members, in terms of how panel members feel constrained in ways that judges don't, panel members feel like they're going to be challenged for being biased by expressing any views of your case along the way. Whereas judges are very open about what they think of your case from day one, and they signal to the parties which way they're leaning on issues. They'll rule early on things that can be taken care of quickly, and it provides settlement opportunities. And that just doesn't exist in the arbitration world.
But it's an interesting point that the pressure on, I'll call it the judicialization of arbitration. I don't know what I'm not an arbitration focused person, so I don't know the term of art that you all use, but I'll call it that. The pressure for judicialization can come from an expansion of judicial review and more decisions overturning on some kind of process grounds. But it can also come, as Kathy said, from the expectations of the advocates who bring with them the notion that we want to take 7 depositions, even though that seems to violate the spirit of doing it quickly and cheaply. But with the expectation of the advocates that we get to take 7 depositions is a sort of tacit threat to the arbitrators, which is, and you better allow us this, or A, we won't come back to you, or B, that will be the grounds that we will take you up. And so the path of least resistance seems to me for an arbitrator is just say, you want 7 depositions? Okay, take 7, take 20, I don't care.
You know, Sam, that actually is not my experience where the parties disagree on that. Occasionally that comes up. But more frequently, I have counsel come in and they have stipulated to a discovery schedule that looks a lot like litigation. And in that situation, I do feel very constrained not to tell them that they can't do what they've chosen to do. It's almost like saying, I'm not going to respect your arbitration agreement.
Well, it seems to me what you have to do is to, before they agree to that, schedule a Rule 16 conference. I mean, you know, you can go the whole way. You can put the arbitrator in a more managerial position vis-a-vis the parties in order to help them constrain the costs. I mean, that was the reforms of the rules of civil procedure starting in 1983 and dramatically expanded in recent years. If the parties are falling back on procedures that are too costly for their clients, I don't, you know, why not go the next step and play a more managerial
Are you
role?
saying managerial where the parties agree that they want to have this many depositions or this schedule, or if they disagree? A managerial approach in arbitration seems to make more sense when there's disagreement between the parties.
Right, but you may also say, can I speak to you about what you consider to be the right parameters of the dispute before we go any further, which is a very typical judicial role. And the question is there any reason to import that here if the cost effectiveness of arbitration is being compromised by the parties' increased expectations, the lawyers' increased expectations that they get the full range of discovery and so forth.
Francis can probably address the practices of other arbitrators better than I can, but I do that. And I still get the pushback that this is what we've agreed and this is what we want you to allow us to do. So I do think that counsel wants to make it look like litigation, and that may be driven by their clients. They don't want to say, you know, I failed to take a deposition and therefore I got surprised at the evidentiary hearing. Maybe driven just by their habit from litigation, but it does seem to come from counsel.
So this is where I think there is a strong difference between court and arbitration, and it's where the balance of power lies. The balance of power when you're in court is all with the judge. You are at the judge's mercy. The judge is going to make the decisions. You are going to be told how many depositions you're taking, if any, and everyone lives with that balance of power. I happen to think that that is the more effective and more efficient setup. The problem with arbitration is that it is all by consent, and that the arbitrators understand that their scope of authority is whatever the parties have consented that authority to be. Now, that could be limited, I posit, to the authority of the arbitrators to decide a dispute. And I think that these procedural issues, I personally think that the panel could constrain the parties even where they agree that there are going to be X number of depositions to be taken. But I understand why arbitrators don't feel that. And they feel like if you agree, this is by consent. And if this is the way you want this dispute to play out, then that's what you've contracted for. That's what you've bargained for. But I think it does lead to what, and this problem, by the way, does not happen in international arbitration. This discovery issue is a domestic US issue. And it is because of the way US practitioners have grown up practicing. I think the cause of wanting, all clients say that they don't want depositions when they draft their arbitration clauses. So when there's no dispute and they're envisioning an arbitration, they will all tell you that they don't want depositions. And then when you have an actual dispute arise, they want depositions. And the reason for it is distrust of the other side. So what happens is that you get to the dispute, you've got two parties who have probably a significant amount of distrust, at least over the issue that's being arbitrated, if not more broadly. So you're often in a divorce situation where you've got a JV that's split up, or you've got a post M&A transaction where it's been hostile, and they don't trust each other. And so then you get to the dispute, and there's a belief on the part of your client that the other side is not going to be forthcoming and producing true information. And that's where you get into the depositions. They don't trust that the document production is going to be done in good faith. And the only way to test that is to get witnesses on the stand, get them to tell you about the documents that they saw or created during the time of the process. And so I do think it's hard to avoid in the domestic context, I think. In my experience, domestic arbitrations do look a lot like court cases, and they tend to actually have more discovery than a court case would, for the reason we're describing, that the parties are allowed to dictate the scope of the document discovery and the scope of the depositions, whereas if you were being supervised by a US magistrate judge, you would probably get less than what you get in arbitration.
That's a fascinating claim. I mean, that would be a hell of an empirical finding if we could substantiate that in any way, because it would turn everything on its head. I mean, I'm not surprised that couples seem to get along better at the courtship stage than at the divorce stage, as a general matter. I mean, that makes sense, but you can think of an arbitration agreement as a prenup, right? That you've agreed to limit how much damage you're going to do to each other at the divorce stage. And yeah, and you know, you can hate each other all you want by the end, but you still have this prenup. And so it's fascinating that the parties are getting out from under their own. If you think about the decision to have an arbitration clause as, you know, we will bind ourselves to the mast because we know that in the moment of passion, we will unfurl all the guns and all the rest of it, whatever metaphors you want here. It's fascinating that I think the arbitrator should say, sorry, you know, you got a contract here, the same contract that gives me authority.
They have the authority to say sorry because the institutional rules give them that authority almost always, right?
So that would be my position. My position would be that you actually, I think the arbitrators probably could be more activist in constraining the discovery, but I understand why they don't want to in most cases.
I'm actually curious as to how you come to that conclusion, because it is by consent, it's by a pre-dispute or a
Right.
post-dispute arbitration agreement. So the parties can agree post-dispute
Right.
to submit
Yeah.
something to arbitration. And I
exactly
don't see how I have the power to tell them that
My-
they've agreed incorrectly.
My interpretation would be it's in the pre-dispute authorization, incorporating the institutional rules that give the arbitrators control over the hearing process, that binds the parties to the decision of the arbitrators in terms of how they're going to deal with discovery. And then your argument, I think, is a good one, but it's, you know, not necessarily obvious that any post-dispute modification to that is essentially an amendment to the agreement. And then that has to trump whatever was previously agreed to in the contract or in the institutional rules.
Right. And that's sort of what I've lived by. I do have parties, you know, agree that even though the arbitration was supposed to be seated someplace else, they both prefer to come to California and I'm going to be the arbitrator, and they agree to that. I don't think that I throw them all out for that, even if they're supposed to be.
But what about if they
seated in
agree to the
bottom.
IBA rules, you know, on evidence and then slightly are uncomfortable with that a month or two later, right?
I'm sorry, what was?
What
the
if they
benefit?
agree to the IBA evidence in guidelines
Mm-hmm.
in the first procedural order, right? And then later down the road, they're uncomfortable with some aspect of the IBA approach. They don't want witness statements, they want depositions or something like that. Do you still then go back and say, well, even though we agreed to that in the first procedural order, we're not going to do that now? So does
I
that make
haven't
sense?
had that particular
Yeah.
thing come up, but my thought would be if they actually both agree, if one of them has a change of heart, no. But if they both agree, I sort of do Sam's approach of counseling them. Is this really what you want to agree? Because this is going to be expensive,
Right.
time consuming, and you initially chose arbitration to avoid those things.
So let me
But if they
flip the
agree-
question a little bit, Kathy. You told me you've done some consumer arbitration, some of
Mhm.
these, what we would call lower value ones. So There, as we know, and as we'll discuss later this afternoon, the question of consent is problematic. The question of contract is oftentimes illusory. Do you have a different approach there of demanding a certain baseline of procedural order despite what might be in the contracted form?
Yes.
And so what's your authority for that? I mean, you're now flipping positions on it.
Well, let me think whether that's actually an accurate answer. I have done consumer cases that fall into the mass filings that I think are going to be the subject of discussion this afternoon. And there is not an agreement in those typical consumer clauses as to how much discovery is going to be permitted. And I am probably firmer on limitations of how much discovery we're going to do unless the parties do agree. And what happens in those multiple filing cases is you actually have sophisticated counsel on both sides. And again, they often come to agreements that are a little surprising. In what I would call a true classic consumer case, I don't see lots of movement on either side to make this, to judicialize, to use your term, and have lots of discovery and multiple motions. They generally do tend to proceed like a classic, almost small claims case.
Right. So let's take now the mass filings for a sec, because basically those cases are before arbitrations because of a desire by the issuing party to avoid mass litigation, most notably class actions. I mean, we all know the reality of this area. And so by taking this step, you are in effect converting this into a class action in arbitration. You're converting it into elements of an aggregated proceeding with the rules that would be more comfortable for aggregated proceedings in courts.
Actually, I think we're not doing that. In the cases
Okay,
that I'm
are you
familiar-
doing that? Let me put it that
In the
way.
cases that I'm familiar with and the ones that I personally have been involved in, there are lots of suggestions to the parties for ways to streamline. But typically those clauses call for an individualized determination by one arbitrator for one case. And if the parties are resistant, as they typically are, to methods of streamlining, like having a Zoom legal argument where 40 arbitrators get to sit in and all pepper counsel with questions and do it once, they don't seem to want to do that for the most part. But I don't think that those kinds of streamlined procedures are things that can be imposed on the parties. I think that would be a real due process problem.
So my experience on this issue is I know lawyers that have called the bluff of companies where there are these adhesion contracts where it says no class actions, no consolidations, no litigation. So arbitration, no class actions, no consolidations. And so some of these really creative boutique law firms like Keller Postman, this has been reported in the Wall Street Journal, have said, okay, we'll file 25,000 individual separate claims against AT&T or against, Amazon or whatever. And of course, the contract to avoid unconscionability, the company is paying for the cost of the entire arbitration. And so the AAA is all of a sudden asking for like multi-million-dollar filing fees just to get the arbitrations going forward. And in that context, once the company realizes what's happening, they often will agree to modify and streamline the process to avoid those sorts of
Yeah,
individual cases.
I don't want to jump into too much into
The future
this
panels.
afternoon panel. I mean, we have Travis Lenkner here is one of the pioneers of this approach, who's going
But
to be on
Sam,
the
may I
panel.
raise one
Yeah,
due
go ahead.
process element of this? The consumer arbitrators are typically, not screened the way arbitrators who are on the complex commercial panel are. And that worries me about these cases, that you end up with people who are essentially members of the public, some non-lawyers, who are hearing individual cases like this. And I worry about the quality of justice across all of those cases when you don't streamline and create some kind of mass resolution.
Okay, we have a few minutes. Are there questions from the audience? Surprisingly, George, go ahead.
I don't want to disappoint you, Sam. First of all, I think an alternative to judicialization, the one I hear most often, is Americanization. So,
Is there a difference between those
no
two terms?
difference. I was very struck, as Roger and Francis were apparently, by the frequency of challenges to awards on the ground that the procedures agreed to by the parties weren't followed. But it's actually in the UNCITRAL model law and the New York Convention. It's sort of, they're sort of orphans. We never talk about them, but to start with the New York Convention, 5.1d, it's under the radar. It's definitely under the radar, but I want to read it. Enforcement may be denied if the composition of the arbitral tribunal or arbitral procedure was not in accordance with the agreement of the parties. And that's in Article 34 of the UNCITRAL model law. So actually what you have observed is literally provided for. So I wanted to mention that. And then finally, Francis, when you were contrasting courts and tribunals, and you were talking about the difference in managerial, I was thinking, can you imagine going into court and asserting party autonomy? I mean, we live by that in arbitration. That's our
That's true.
touchstone,
Yeah.
party autonomy. And that has driven a lot of your responses, including Kathy's. And no, not in court.
Right.
Not in court. And lastly, I don't know what I'm supposed to take away from this panel by way of a cure for due process paranoia. I think I'm supposed to become less paranoid.
That's what I mean, that's my view, is that I think that it's very rare to see courts overturning awards, but I think this issue of the arbitrators needing to follow the agreement of the parties is probably right. That I think the arbitrators should be sensitive to that, and it sounds like they are.
I think due process paranoia ought to run both ways, right? We ought to be worried that people aren't getting due process in arbitration and courts are enforcing nonetheless, as well as the notion that courts are coming in and undoing properly conducted arbitration.
In other words, George, even paranoids have enemies. Yes. Go ahead.
Okay, thank you to the panel for a wonderful presentation. But my question is, where do we find the balance in terms of what we're looking at, the outcome, right? The outcome is enforcement of the arbitral award. You want to be sure that you're working off with an award that you can enforce in the local jurisdiction or in the states or in any other jurisdiction. So that should be the fundamental notion in every litigator, in every arbitration's perspective. But now the question becomes, you're talking about due process. Where do you find the balance in ensuring that the award is enforceable, it conforms with due process standards in your jurisdiction or in the seat and in other jurisdictions of enforcement, with meeting the criteria of efficiency, party autonomy, cost effectiveness? How do we keep that balance? Because at the end of the day, I wouldn't want to sacrifice the outcome on the altar of efficiency, on the altar of party autonomy, on the altar of expeditious hearing of proceedings, and then walk out with nothing.
I would only want to point out that as an advocate, it's only the claimant that wants an enforceable award, not the respondent.
Right, but the question is a hard one, because if you have an arbitration panel in California, for example, but you know that the award has to be enforced in Germany or pick any other country where the assets might be, what standards of procedural order do you use? Because yes, we have very robust due process style arguments in the United States, but they may be completely different than under the European Convention. Do you think about that, Kathy?
You worry about being fundamentally fair, I think, as opposed to any particular content of due process. So I'm not sure that's entirely responsive, but I never know at the time of an arbitration where people are training to enforce it.
Right,
So
exactly.
I can't be specific.
I think as a practical matter, the reason that the ICC exists and is utilized so universally in international contexts is because of exactly this issue, that the ICC standards have become accepted in so many different jurisdictions, that if you're really worried about enforceability at the outset, you're picking the ICC as your arbitral institution, principally for the reason that you actually want to ensure that you've got enforceability in as many countries as possible.
Judge Shinlin?
Thank you. Well, I have been on both sides of this. So what Francis said is absolutely right. In the courtroom, the judge has all the power, and the judge will try to shape and limit discovery. And now that we have a proportionality rule, we have even more power than we had before. And we're not at all reluctant to deal with motion practice. So now that I've become an arbitrator, I was shocked at the complete reverse of that balance. What we say in arbitration is, it's your process. You chose it, it's your process. We're going to defer. And I think we have to defer to the parties if they agree. You can try, Sam, to push back. You can try to have that initial conference and say, do you really need this? This is not a large case, or it's not that complex a case. But if they listen to you and then say, thanks for your insight, but we disagree, this is what we want. If you wish to be hired again, and all arbitrators want to be hired again, they will not impose their view when you have consent. So I do want to say that I was very put off that arbitrators will not grant motions to dismiss, which stare them in the face, that require dismissal. But there's a self-interest. I'm sorry to tell you, there's a self-interest in going forward. And I've been on panels where I'm the only one of the three and say, we have to grant that. And the others don't want to grant it. They're worried. As you said, there's this fear. We haven't provided a hearing.
Yep.
We haven't provided an opportunity to be heard. So they don't want to take it out on motion. Finally, jumping back to the court side, the judges defer so much to the arbitral award, they almost never vacate. I heard your statistics, but the reality is if you vacate, you'll be reversed quickly.
Yeah.
It won't stand. It's rare to vacate here in the US, and the judges all know that. There's a great deference to arbitration as part of our legal culture, going all the way from the recent,
I heard you say
the
two
recent
arguments.
Supreme Court.
I heard you raise two arguments. One, you want to defer to the parties because you want to be reappointed. That's a
Yeah.
totally different motive than
Yeah.
I want to defer to the parties because I don't want to be successfully
Both.
challenged.
Both.
And you're saying they're equally motivating.
Oh, absolutely. Equally, you're fearful that there's going to be a ground that they didn't have an opportunity to be heard. That's something arbitrators think about. But the other one is the reputation. Well, she doesn't grant hearings. So there's a problem there. But I just want to talk about the court side too. Our legal culture from the Supreme Court down is to defer to arbitration.
Franco, do you have any?
No, I have a very different view. I do not believe that much deference is indeed given by courts all over the world to decisions by arbitrators, not even in the US, in respect, for example, to issues of challenges. So the fact that an institution looks at a challenge does not mean that even US courts look at that issue. Again, of course, US courts defer to decisions by the institution if the issue is interpretation by the institution of its own rules on a lot of other issues, but really not as much on challenges. I like what Francis said earlier in the sense that there is too much due process paranoia. Arbitrators are indeed not too courageous. And in my opinion, too often do indeed, because they are afraid of their award not being enforced or even worse, annulled, they do not comply or apply the law or the rules strictly because they are afraid that their decision will then be annulled. Here at NYU, at another center, we have organized a research on this. We have published a book, 17 country reports, and it is clear, as mentioned by Francis, that you will not get a lot of annulments or non-enforcement decisions because of due process violations. It happens really very, very rarely.
you can't come to our center and advertise for your center here. There are jurisdictional boundaries that will be enforced. So I'd ask everybody to
We're
disregard the
just happy
last
to be at
comment.
NYU. Sam. So we're happy to be at NYU. So.
So I think we are at the end of our allotted time. So would you please thank our panel?